Well, you're listening to Meeting House here on Faith Radio. It is the 2024 National Religious Broadcasters Convention in Nashville. Matt Staver, founder and chairman of Liberty Counsel, joining us today. You can hear Matt on Freedom's Call. Comes your way just after 8 o'clock, weekday mornings on Faith Radio, as well as weekday afternoons at 3:57, just before the Meeting House begins at 4 o'clock. And Matt, I always pick up a nugget of information because I'm sitting there in the studio on most days listening to your commentary, and so it's an inspiration, and I've even been known to actually comment on what I have heard you say prior to my program. So we count you a tremendous partner with the Ministry of Faith Radio. I know you have been involved in cases in the state of Alabama as well as around our nation. In fact, there are a number of different headlines that we are going to be talking about today, and the first of which, in fact, as they say in the sports world, I called an audible on you, and you had mentioned to me about the involvement, in this case, Alabama Supreme Court, with respect to the humanity of frozen embryos, a key case that has been handed down by the Alabama Supreme Court as of late. Inform our listeners about that.
Well, thank you, first of all, for having me on your program, and thank you for carrying Freedom's Call. And we certainly appreciate your ministry getting the word out throughout the airwaves. But on this particular case with the Alabama Supreme Court, it's a big case because it recognized a person from the moment of fertilization. And it's involving an in vitro fertilization case with three couples that had their eggs fertilized, so they have a fertilized embryo, and they were being stored in a cryogenic freezer by this IVF clinic in Alabama in Mobile. Some patient wandered into the back, opened up the cryogenic freezer, and out fell these frozen embryos that were fertilized human beings that were in the freezer, and they died. And so the three couples filed a lawsuit against the facility for wrongful death. The Alabama Supreme Court looked at that and said, well, is there a wrongful death cause of action here? And the only way you'd have a wrongful death cause of action is if what we're dealing with is a human being. Yes. And so the Alabama Supreme Court, in a 7-2 decision, ruled that from the moment of fertilization, you are a human being. It doesn't matter your location, inside or outside the womb. From the moment of fertilization, that is a human being. It is protected under the law. And so the family members can actually pursue a wrongful death claim against this IVF clinic that allowed this patient to come back there and kill these innocent human beings. That is a big case. And in fact, there is a concurring opinion by Chief Justice Tom Parker, who said that Alabamans, both in the legislative laws, have recognized the humanity of the unborn child, whether it's in criminal law or some of these other laws, wills, trust, and estate laws. The child is recognized as a human, entitled to all the rights that anyone who's born alive is entitled to. But also Alabama has changed the Constitution to recognize the sanctity of human life. And in Alabama, it's like the people said from Jeremiah chapter 1, that I knew you in the womb before you were born, I formed you. And he actually cites the scripture verse. Amazing decision out of the Alabama Supreme Court. But I want to talk about it a little bit later, how that particular case will make a ripple and is already making an impact in other states, like, for example, Florida, and what other states can do similar to Alabama.
Matt Staver joining us today here on the Meeting House on Faith Radio, the voice you hear on Freedom's Call on Faith Radio, founder and chairman of Liberty Counsel. This is the Meeting House NRB, National Religious Broadcasters 2024 in Nashville. Well, I think about the citizens of Alabama going to the polls and affirming or passing that constitutional amendment, affirming human life. And also, you have the Human Life Protection Act, which is a strong bill, of course, until Roe v. Wade was overturned in the Dobbs decision. It was in court that day, and we rejoice in that, the Human Life Protection Act in Alabama. So Alabama has passed some pro-life laws. What do you see, and let's talk about the impact of this law now, not only within the state of Alabama, but also, as you mentioned, the ripple effects that are occurring.
Yeah, let me first of all begin with Florida, but Florida is an example of the rest of the country as well. In Florida, I recently argued at the Florida Supreme Court regarding a ballot initiative proposed by Planned Parenthood and the ACLU to put on the ballot in November an amendment to change Florida's constitution that, if passed, would allow abortion at any time for any reason up until including birth. Very radical. Every law, if this were passed, would be overturned except for possibly parental notification, but every other law would be gone, including health and safety regulations. There would be no ability to regulate abortion if this passes in the Constitution. So my argument at the Florida Supreme Court was several-fold. One, it violates Florida law to put this on the ballot because it's deceptive and it's intentionally so to deceive the voters. Number two, it violates the single subject rule. Different requirements that are necessary to put a ballot initiative on the ballot. But during the oral argument, the Chief Justice of Florida's Supreme Court asked the question. And he said he's concerned about what the ballot summary does not say. And so when the voter goes to the ballot box, they need to be apprised of what they're voting for, including the impact of what this might do to other existing laws and rights. So he asked the question about existing Florida constitutional provisions. Article 1, Section 2. A natural person is entitled to the right to life. He says if that includes an unborn child, which it may well include, then this is taking away a right that's already in existence, and the voters need to be informed of that, and the ballot initiative doesn't inform them, so it can't go on the ballot. That was his point. So what we did is we filed, after the argument, lots of cases and statutes from Florida. I'll talk about that in a minute, but we also filed the Alabama Supreme Court opinion that just recently came down to show this is what Alabama has ruled and this is what their law is. And so exactly right, when it mentions person in our Constitution, who does that include? It includes an unborn child. But here's the big thing that goes beyond Florida and also the other states. Virtually every state is similar to this. In every area of law outside of abortion, the humanity of the unborn child is recognized. In criminal law, for example, if you murder the mother who's pregnant, you can be prosecuted for murder because of the mother's death, but also because of the unborn child who's also murdered. Yeah. If you do vehicular homicide, same thing. There's 2 vehicular homicides against the mother and the unborn child. If you cause an injury outside of criminal law, but you have civil damages for what you did to the mother and to the unborn child. Now, if you die and you leave a will, and there are people that are born and they are entitled to some of the property, they have a right to come to court and argue their entitlement. But if a child is in the womb at the time of death, that child can be appointed a guardian, and the statutes call it for the unborn child to argue on behalf of the unborn child's property rights just as though the child was born. And Florida is not unusual. Virtually every state, and Alabama is included, besides the constitutional provision, Alabama has those kinds of laws as well. Virtually every state, in every area, criminal, civil, guardianship, wills, trust, and estates, they all recognize the humanity and legal rights of the unborn child. And that means when a constitution provision, which they all say, person has a right to life, that would include the right to an unborn child as well. So that's an argument that can be and should be made across the country. It's one that we're making at the Florida Supreme Court. It's one clearly that Alabama has already made.
Well, let's talk about in Alabama, and I do want to talk about the Florida case as well, and even go back to the decision of the voters in Ohio back in November, because this is, well, really the whole area of these ballot initiatives have become deeply concerning from a pro-life standpoint. But just in doing a cursory reading of some material, seeing some headlines with respect to the Supreme Court ruling among the media, it's like, well, this is something that's going to be harmful to the fertility clinic industry. This is a decision that could potentially put fertility clinics out of business. So there's been a lot of negative media about this life-affirming decision by the Alabama Supreme Court. What would be your response?
That's not surprising from the media because they're not wanting to have any kind of protection for the sanctity of human life. They're going to parrot the Planned Parenthood and ACLU talking narrative. But this is not going to put anyone out of business, but it will make these organizations responsible for what they're dealing with. And what they're dealing with when they have a fertilized egg and it becomes an embryo that is fertilized, that is a human being. What else is it? Is it a blade of grass? Is it an insect? It's a human being. It has identifiable DNA. The DNA, the hair color, the eye color, different kinds of propensities, whether it's disease or strength or height or any other kinds of physical characteristics, they're all imprinted at that moment of fertilization. You are a unique human being. The only difference between that embryo and you and me is time and replicating more, and all throughout our entire life, whether it's conception all the way to natural death, we are continuing to grow and our bodies are continuing to change. So that begins at the moment of fertilization.
Matt Staver of Liberty Counsel joining us today here on the Meeting House on Faith Radio. You can hear him on Freedom's Call on Faith Radio. He is the founder and chairman of Liberty Counsel, joining me today here on the Meeting House on Faith Radio at NRB 2024. Well, Matt, let's go back to the Florida proposed amendment. I know in Alabama we have a situation, if something's going to be placed on the ballot as a constitutional amendment, it actually has to come through the legislative process. Obviously, you have some states, Ohio being one of them, perhaps, right, where it can go directly from a number of signatures on a petition directly to the ballot, which to me seems like it really makes it very vulnerable to having some bad language in these proposed amendments. We've seen that across the country. In Florida, fortunately, you and like-minded individuals have stood up and said, let's review this. Apparently, Florida has a direct ballot process as well, or does that come through the legislature?
There's 4 ways in Florida to amend the Constitution. Okay. One, you can do it through the legislature, and it goes directly to the ballot, and you vote on it. 2, you can have, every 20 years, we have a Constitutional Revision Commission. It's a committee that is formed, goes throughout the state, takes public input, and proposes constitutional amendments. You can have a constitutional convention. And the 4th way is the people can gather enough signatures based upon the previous presidential election. You have to have like 8% of those who voted in the prior presidential election, and then you have to have 8% in all the different districts and precincts. So you can't just get all your signatures from one place to the exclusion of another. So it has to be evenly distributed. And then what happens is, when you get enough signatures, it goes before the Florida Supreme Court, and they have to make sure it's in compliance with 2 things. Number 1, it's not deceptive, and that it's clear, so people know what they're voting for. And number 2, that it only addresses a single subject, so when your yes is on yes, it's only on that issue, not yes on this, but maybe yes on something else that you're not really concerned about. Very narrow, single subject. So that is dependent differently from different states. Ohio has a similar situation. Now, Florida, to your point, some years ago, it was just getting the signatures, and then once you get it on the ballot and you pass all that procedure and you get it on the ballot and they vote for it, back a number of years ago, it's a 50 plus 1%, just a little over 50% you have to pass anything, a majority. So we had the organizations down in Miami, and they wanted to protect pregnant pigs. Yes, pregnant pigs. So that they would be treated humanely if they're pregnant and they're caged. So they got an amendment on the Florida ballot, and it passed. So in Florida's Constitution, we have a provision that protects pregnant pigs. Well, the people got upset with that and said, this is crazy. We need to raise our threshold when it's a voter initiative to 60%. Ohio tried to do that.
They tried to do that, that's right.
And the voters did not pass the 60% threshold. The 60% threshold will cut out a lot of these crazy things, like the pregnant pig ballot, and it would have also derailed the abortion initiative in Ohio because it passed over 50% but less than 60%. So they need to go back and change that. But right now, this is unfortunately one of the issues in the Constitution in Ohio. And I think the other thing that we need to say is we need to go back and reform that. But finally, we need to get the churches involved, because the churches and the people should have gotten involved, and that should have not come anywhere close to 50%.
Yes. And so very quickly, in Ohio, is there any recourse from a legal standpoint? I know some legislators were trying to get together and perhaps address it in the legislative process. What are you hearing out of Ohio as far as perhaps stopping this horrible amendment?
Well, there's some things that are going on in the legislature. There's things that are still going on in the courts to challenge that. But I think what they need to do is go back and repeal it. It is not as liberal through all 9 months as the Florida one would be if it got on the ballot, but it does put abortion into the Constitution. That obviously has to be reversed. And we need to make sure that other states don't follow Ohio's example.
Well, we understand, and you mentioned, and you took you took this to the Florida Supreme Court, taking the organizers of this drive to task for the deceptive language. That seems to be a major problem in state after state. People have no idea what they're voting for.
No, because, when they went out and got signatures, they would tell people, this is for women's rights. And until you persisted, they wouldn't tell you what it was about. So it was very deceptive from the very beginning.
Liberty Counsel website.
lc.org, lc.org.
Matt Staver, thank you so much for all you do in upholding the cause of Christ. Thank you.
Thank you. My pleasure.